Hello, everyone, and welcome to Uncivil Law. And we have an exciting, spicy, international child custody case. This is in the matter of Kareem K. versus Basim A. In this matter, a father is winning custody rights, and it is a complicated legal nightmare. It involves international law. It involves marriage overseas and divorce overseas. It involves children living overseas, Islamic law, all kinds of good stuff. So this should be really good for my monetization. Let's get started with this. On September the 11th, 2002, which, I will take note that it's exactly 1 year to the date after the September 11th attacks. So one has to wonder whether that date was, chosen by accident or not, or was done deliberately to celebrate like an attack against the United States, because given what we're talking about, deciding to celebrate an attack against the United States seems more likely. So they got married exactly a year to the date after September 11th, presumably to celebrate that event. The parties were married in a religious ceremony under the strict tenets of the Muslim religion in the city of Ib, country of Yemen, where they remained until 2005. Yeah, so we got a couple getting married a year to the day after the September 11th attacks in Yemen in a strict Muslim religious ceremony. Might have something to do with celebrating the attacks on 9/11, just speculating. Both father and mother were born in Yemen, but only she became a United States citizen. Their union was blessed with the birth of 4 children, all daughters. It is undisputed that father, mother, and child would frequently travel back and forth between Yemen and the United States. In fact, in the spring of 2016, mother voluntarily left New York to travel to Yemen with father and children to participate in Ramadan and Eid celebrations with the family in Yemen. Although she was expecting to return with the children for the start of the school year, father allegedly made a unilateral decision for the family to remain in Yemen, which, is not a problem in any way under the Islamic religion, right? Or the Muslim religion, right? Especially in a country like Yemen. It's not like, the man can just direct these things and order these things, because there's no issues with this in the Islamic religion whatsoever, I'm sure. This apparently was the preamble of father's controlling behavior and physical and verbal abuse that she allegedly endured throughout the marriage. You think Collins Razor says no? Really? I don't know, man. I mean, I'm open to debate, but I'm open to debate on it. But to me, yeah, I mean, it's a pretty notable event, right? And they're Muslim and getting married in a religious ceremony. I don't know, man. I don't know. I don't know, man. You could be right, but I don't know, man. According to mother, father's behavior prompted her to leave their marital home in Sana'a, Yemen, without the children in November of 2018 in order to reside with her brother in a distant Yemeni city. Upon learning that father married a second wife, and because of threats, mother indicates that she never intends to return to the marital home. Instead, the mother later traveled to the United States to be with her parents in New York in April 2019, again, leaving the children behind. This woman is special. By order to show cause, dated October the 9th, 2019, the mother commenced with this instant proceeding against the father in Kings County Family Court. That would be New York, by the way, for you who are wondering. Kings County. Not the Isle of Manhattan, but one of the other islands is Kings County. By filing petition for writ of habeas corpus and custody, seeking an order that would direct the father to make travel arrangements on behalf of the children to enable them to come to New York, commanding him to surrender his and children's passport and other travel documents to the court, requiring father to remain in the jurisdiction of the court during the pendency of the proceedings, granting mother temporary legal and physical custody, and prohibiting father or anyone else under his direction or control to arrange any marriages for any of the subjects of the children during the pendency of the action. So we're looking for a U.S. court to prohibit an arranged marriage because, again, Muslims and Islam, religion of peace, this would never be an issue in any way. That day, mother, who appeared in court fully covered in a burqa, also filed a family offense petition against the father seeking an order of protection on behalf of herself and the children, reporting that she had fled Yemen due to domestic violence and repeated acts of sexual and physical abuse committed against her by father. Anytime you're alleging sexual or mistreatment abuse in a family custody case, in particular, you have to wonder if it's legitimate or if it's just being used as a prop. Because, not that, anyone would ever lie about, sexual violence or anything. Not that anyone ever would lie about or exaggerate a Me Too movement in any way, because every one of them is 100% true. But if a person were to exaggerate one might do so for the purpose of child custody hearings. So, although such a thing has never happened ever, because, Me Too can never be a lie, a child custody judge might want to be aware that perhaps this isn't really reflective of reality. Well, let's go on. I don't know who here on YouTube is also on Lawful Mass's Discord, but I had one hell of a debate today between me and pretty much the entire rest of Discord, because I called COVID the Chinese virus, and they tried to correct me, and then I argued against them for quite a while, and became quite a bit of a bitch fest with them bitching at me and me bitching at them. It was great. On the return date, that would be the return for the subpoena. So when they talk about the return date here, they don't mean like return to the country or something like that, like travel. When they talk about the return date, they mean the return for the subpoena. So when you subpoena someone, the date when you have to do the first answer, first response, was called the return date. So technical note. On the return date, mother appeared with counsel who reported that service of the subpoena had not been effectuated upon father. Upon counsel's application, the court issued an order for substitute service by electronic means with respect to custody and visitation, and personal service with respect to family offenses proceedings. On October the 28th, 2019, it's a very interesting thing, and I don't want to the whole interesting thing of it is very interesting, because they are one of my minor criticisms of my good friend Larry French, who is my friend. I genuinely mean that. One of my criticisms of him and how he runs Discord is he is so loath to ban anybody. They'll give everyone 3 billion chances. But I have a sneaking feeling that they're not going to be as generous to me one of these days. I have a sneaking feeling that one of these days they're going to decide my conservative beliefs have gone too far and I have to be purged. So, yeah. It's a CCP virus. What does CCP stand for in that sentence? Communist something? Communist China something? What is CCP? On October the 28th, 2019, mother submitted proof that father was served by electronic means. Mother also notified U.S. State Department so father could be placed on a no-fly list. Very nice touch. Chinese Communist Party? Okay. By order to show cause of November 2019, father moves for dismissal of mother's petition for the writ of habeas corpus and custody on the basis that New York Family Court lacks subject matter jurisdiction under the Uniform Child Custody Jurisdiction and Enforcement Act embodied in domestic relations law, because the children have undisputedly resided with him in Yemen for the past 3 years pursuant to mother's consent. And we have covered this a little bit before in the past, but very broadly, there is an international law dealing with child custody issues, because as you might imagine, from time to time, parents are of different citizenships, and the kid might be of a different citizen, yep, still. And so as parents are, taking kids across lines and whatever, in an effort to circumvent child custody proceedings, we had to have an agreement as to where these things would be heard. So basically, we came up with an international treaty. And the international treaty, which we've covered before, again, very superficially, says the jurisdiction in issue for child custody issues is the one in which the child primarily resides or has resided. So the idea being if they have resided for, say, 3 years in the United States, and one parent took them overseas to a country that's within this treaty, the proper jurisdiction is inside the United States, because that's where they habitually resided, and vice versa. So it's an idea of where should this case be heard. So we don't have issues of parents stealing each other's children, and we don't have issues of courts of different countries issuing conflicting rulings. So the idea is to have an international rule that everyone can more or less agree with, and that's what we're talking about. By an order to show cause, father moves for dismissal. Okay, we covered that. Father argues mother's petitions are replete with lies, exaggerations, and omissions. Not possible, right? Including the fact the parties were in fact divorced by and attestation divorce documents dated 2019, executed by them and issued by the Ministry of Justice Court in the Republic of Yemen. So they're potentially divorced. Okay. The divorce specifically refers to a settlement between the parties whereby, among other things, the father was awarded custody of the two older children. The mother got custody of the two younger children until the children reached the age of 11, unless she, the mother presumably, got married or traveled to the U.S. Father was permitted to travel with the older girls without condition or restriction. Mother was granted visitation with them, and father returned her dowry, passport, and paid the sum of $10,000 to mother. The divorce document is signed by father, mother, and 4 other witnesses, including brother at the grandfather's home. Also, I don't want to brush unduly by the fact that the father returned her passport. So I'm not an expert on this issue by any means, but I believe it may be true that in some countries of the world, even if the woman has a passport, the husband has the right to keep it and possess it and not give it to the wife. And so when I read here that the passport was returned to her, what I'm understanding that to mean is that he was holding possession of it to the point that she would not be able to get a hold of it. Which, if it's a U.S. passport, that's really, really scary. But that's the way I'm interpreting it, that he was holding her passport, even though it was hers, and it was legal under their law. So that's concerning. The divorce document is signed by father, mother, and 4 other witnesses, including brother at the grandfather's home. That divorce was modified by a later document, whereby the mother agreed to give full custody of all the children due to impending travel. On November the 26th, 2019, mother and father appeared with their attorneys, who accepted service on all the pending matters. Following contentious oral arguments, this court denied father's application to stay the order and further ordered father to surrender his traveling passport to his attorney, who shall safekeep it as an officer of the court. It appears father failed to comply with those directions. As a result, by a second order to show cause, mother moves for an order holding father in contempt for court for continued failure and refusal to abide by court's orders, and for a warrant for father's immediate arrest and return to this court's jurisdiction. Mother's counsel reports to the court that father had not only failed to surrender his passport, but he left the jurisdiction by returning to Yemen. The court denied mother's counsel's insistent application for the warrant and adjourned the order to show cause where mother, her attorney, and father's attorney appeared. The court noted that father claimed and provided medical proof that their older child had medical and cardiac problems, which required his attention, and the father is not coming back. Mother expressed disbelief that this child was sick. Upon the application of mother's attorney, the court issued a temporary order for visitation, directing that the mother was to have regular contact with the children 3 times per week by telephonic or electronic means. In opposition to father's motions, mother maintains that she and children remained in Yemen not by choice, but by circumstance, as they had no means to travel, which may be true if the father was, keeping their passport. Fears father's retaliation and political connections with there's no way I'm going to pronounce this correctly, Houthi government, and reiterates that father engaged in physical and verbal abuse with her. Faced with executed divorce documents, mother finally acknowledges the existence and claims for the first times that she's forced to sign the divorce documents without an opportunity to thoroughly review. So she's forced to sign, which, given the region of the world this is in, could be plausible. Because father, brother-in-law, and another man arrived at her residence uninvited and carrying firearms, in addition to traditional Yemeni knives, and she feared for her and her family's life. With respect to jurisdictional question, mother argues Yemen cannot be considered the children's home state based on circumstances of their stay there, which, given what little I know about this particular law and the international application of it, that is kind of the standard, but we'll see what happens. That the parents and children have significant connection and substantial evidence in New York. After reviewing the circumstances, court disagrees with mother. So, on the one hand, the family court agrees with the father and gives child custody. On the other hand, he's giving them child custody to the point that they're going to go to Yemen and live there under the Islamic Muslim religion. So the commenters below can decide whether or not they're happy that a father won a child custody case, or they're unhappy that a person of this particular religious persuasion won the case. So that should be interesting in the discussion, I'm sure. The international law that governs the United States court's jurisdiction in international custody and visitation matters New York courts have jurisdiction to make initial custody determinations if New York is the child's home state. Under the relevant law, home state is defined as the state where the child lived with a parent or person acting as a parent for at least 6 consecutive months immediately before the commencement of these proceedings. Applying these principles to the case at hand, the father's motion must be granted as Yemen is the child's home state. Mother, a resident of New York, claims she voluntarily left New York to travel to Yemen with father and children in 2016. Allegedly due to physical, sexual, and verbal abuse, mother left the marital home in Yemen without the children in 2018, and then traveled to the United States in 2019, again without children. Thus, it is undisputed that children have resided in Yemen with father for several years prior to commencement of these proceedings in New York. Although mother would have a basis to argue subject matter jurisdiction if she and father were New York residents, even though the children live abroad, the record reflects no proof of father's New York residency that has been submitted to the court, and New York is not the child's home state. In contradiction to mother's statements, father presents divorce documents issued by the Ministry of Justice Court in Yemen, granting him sole custody of all 4 children, the 2 older girls as per Yemeni law, and 2 younger girls upon mother's consent. The divorce documents show that they were signed by mother and father while witnessed by 4 individuals. Now, mother belatedly argues that even if she signed the documents, it is under duress or fraud by armed individuals, and that she's not aware she's giving up custody of her children. Now, mother belatedly argues that even if she signed the documents, it was under duress or fraud by armed individuals, and that she was not aware that she was giving up custody of her children. Even if this court were to concede the circumstances involving the signing of the documents are suspect, this by no means affects the jurisdictional question of this court. And that's fair enough, because we're looking to, does this court have the power to hear this case? That's jurisdiction. Can this court hear this case? There's an international treaty that applies to this circumstance. So as a result of this, no, because the children lived in Yemen for 6 months, therefore the Yemeni court is the proper jurisdiction. So if you want to argue that this divorce document is fraudulent, if you want to argue it was under duress, go argue it to the Yemeni court. Let us know how it turns out for you. I mean, not to put too fine a point on it, but you did go to Yemen and get married in Yemen, and it's a Yemenis agreement. So, it's a Yemenis marriage and governed by Yemenis law, such as it is, and Yemenis marriage and divorce law, Yemenis family law. So, you invoked the Yemenis law by going there and getting married, and now you have to be governed by that law on the tail end of that too. So, this is if you play these games, these are the prizes you win, I guess. Mother contends Yemen should not be considered a home state or a viable jurisdictional alternative, since child custody laws, as written or applied, violate fundamental principles of human rights. Be that as they may, they are Yemenis laws, and, we have to govern by their laws, and they have to govern by our laws. These are the agreements we've reached on. She further contends the Yemenis laws regarding women's rights and domestic violence are also on par with human rights violations. Again, you did get married in Yemen, and Yemenis law is going to have some impact on this. It's marriage can be thought of as a contract. It's a special kind of contract, but it's governed by law, and the termination of it, otherwise known as divorce, is governed by law, and child custody is governed by law. And so if you go and invoke Yemenis jurisdiction, they're going to have some interest in this. So, now that you're on the flip side of that, it's like, you had to see that coming a little bit, I would think. With the ensuing civil conflict, including bombing campaigns, Mother argues that access to whatever legal system exists has been even further curtailed. Moreover, she maintains the situation in Yemen is dangerous and not safe for children. Here, it is apparent that Yemen is in the process of undergoing a civil war, and more likely that Yemenis law regarding domestic violence, child custody, and basic human rights do not conform to our expectations of the state of New York. However, this would not appear to be a Hague Convention case. Countries that participate in the Hague Convention work cooperatively to ensure children are returned to their country of habitual residence. However, Yemen is not signatory to the Hague Convention. Besides Yemen, there are numerous non-Hague Convention countries which have declined to participate in Hague's international effort to prevent the abduction of children. Regardless of whether one agrees with the values and practices prevalent in various cultures around the globe, this court is not jurisdictionally empowered to make broad public policy, finding Yemeni laws violate fundamental principles of human rights and thus should not be considered a viable jurisdictional alternative or home state. I guess this is the consequence when you try to argue that every culture is equal to every other culture. And there are no cultures that are better than any other culture. So Yemenis culture is just as good as every other culture, notwithstanding whatever differences they might have when it comes to women's rights, child's rights, marriage rights, divorce rights. All cultures are equal. Okay, sure. The Yemen, you don't know about the Yemen civil war, man? I mean, there's been some problems in Yemen. There's been some problems in Yemen. It's been a country under some problems. In any event, it's clear from the record that father did not abscond with children to Yemen, but the parties traveled to Yemen as a family. Mother has provided no proof that her stay in Yemen was supposed to be temporary, or she's unaware of the U.S. Department of State's warnings applicable to those traveling to Yemen. The United States government tried to tell you, man. Additionally, mother did not leave the Yemeni marital home until 2018. Furthermore, there's no indication from the record presented that the father has harmed the children. While Yemen presents itself as a dangerous place to raise children due to civil war and conflict, and the mother is concerned that the oldest of the girls may be forced to marry in the immediate future, not that that's a problem, of course. All cultures are equally valid and equally good in every way. So, cultures that force child marriage are just as good as any other culture. Not that that would ever happen, of course. Presumably in accordance with local custom, there appears to be no imminent risk of harm. One can be only optimistic. Good luck. The father will consider his daughter's best interests in determining whether to return them to the United States or making other decisions to their future. That is a lot of optimism. Father will consider his daughter's best interests. Okay, that sounds like a thing that might happen. As such, this court also declines to exercise temporary emergency jurisdiction. In accordance with the foregoing, this court hereby grants father's motion to dismiss based on the fact that New York cannot claim subject matter jurisdiction or emergency jurisdiction because Yemen is the home state of the children. So that is the end of the case of Kareem K. versus Basim A. In this case, we learn that two people got married on September the 11th, 2002, exactly 1 year after September 11th, in a religious ceremony involving the Muslim religion in Yemen. And fast forward, things have not gone well. And the mother would like to apply things in U.S. law. But the U.S. is part of an international treaty governing child custody. And child custody says that the rules that apply are those of the country to which the child is accustomed. In this case, that would be the country of Yemen. So if you feel that the divorce was improper or coercive, or you feel that child custody issues are, not going your way, feel free to avail yourselves of the Yemenis court. Let me know how that goes for you. And that's the end of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.